Welcome back to one more session. Today in this session, I'm going to explain about what is tort. The word tort is a Latin term, tortum, which means twisting out. In popular, in general, the tort implies or which indicates conduct, conduct, conduct which is twisted or unlawful act or wrong. So simply, tort is nothing but it's a wrong, unlawful act. The term tort was introduced into English law by Norman jurists. Those wrongs are unlawful. Those wrongs are unlawful acts which violate legal rights of a person, for which law provides the remedy of unliquidated damages. Law of tort is not a codified law. So, law of torts is uncodified or unwritten. It is based on common law of England, which is unwritten and uncodified. The law of torts signifies violation of great variety of rights and duties, and so it is very difficult to give a concise and complete definition of it. It is an ever growing law, and the courts are expanding its horizon continuously by recognizing new torts. In view of these reasons, it is not possible to give a perfect and scientific definition of the law of torts, which would include all its aspects. In spite of this difficulty, many jurists have attempted to give some definitions. Some of the leading definitions are, which is given by Salman, Fraser, and Dr. Winfield. So those are popular jurists. They are given a brief or a definition. According with them, they explained about tort. First, coming to Solomon. According to Solomon, a tort is a civil wrong for which the remedy in common law is action for unliquidated damages. So what is the meaning of liquidated, unliquidated means? So liquidated damages are nothing but where compensation is fixed. Unliquidated damages means, so we can't means just before we discussed that tort is uncodified, so that unliquidated means the compensation of particular tort was not decided by legislation, and which is not exclusively the breach of contract or the trust or other merely equitable obligations. So it also says that breach of contract or the trust or the breach of other merely. So these are not exclusively can be considered as a torts. Thus, according to Solomon definition, a tort consists of the certain essentials that are tort is a civil wrong. This wrong is different from breach of contract or breach of trust or other equitable obligations. This tort is redressable by an action for unliquidated damages. So let's see another definition which is given by Fraser. According to Fraser, a tort is an infringement of right of a private individual giving a right of compensation at the suit of the injured party. And coming to another definition which is given by Dr. Winfield, according to Dr. Winfield, tortious liability arises from breach of duty primarily fixed by the law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. If you observe this definition, it has certain essentials that are nothing but tortious liability arises from breach of duty fixed by law. This duty is towards persons generally. Breach of duty is redressable by an action breach of duty is redressable by an action for unliquidated damages. These are various definitions. According to that, there are certain conditions which must exist before a person is held liable in tort. The elements which have come before us are in fact the conditions on which tortious liability is determined. So simply to say whether a particular person is liable to tort, there should be certain elements. Those are, there must be a wrongful act, there is a legal damage, for the damage there should be a legal remedy. If these three elements are fulfilled, act is done by the person, damage is held, and remedy also can be provided. If these three elements can exist, then it is said to be a tort. Once again, I am repeating that there are certain conditions which must exist before a person is held liable in tort. There must be three elements that are wrongful act, legal damage, and legal remedy. Thank you.